their own studies, women find helpful in confirming their decision. So, sorry, abortion providers, you lose. All right? Equal protection, you lose under Danforth. Truthful, compelled speech, you lose under Casey. They then argue that it's sex-based discrimination, that there are no circumstances under which we would require a man to undergo an ultrasound prior to any medical procedure. But that just goes back to our equal protection argument. The court rejected that years ago, right? That the abortion laws target women over men, and said, no, the distinction is pregnant women over all other persons. And so they lost on that one. So finally, they argued that there's a vagueness problem with these laws. And the vagueness problem, they argue, and I confess, this is the only place I will, I hope, slip into snarkiness. So, snarky flag. All right. In all of these cases, you were dealing with people that have graduate degrees in one of the most complex areas of life, medicine. And yet, when we deal with abortion statutes, they lose the most common ability to understand the English language. It is really quite stunning. The Texas abortion providers said that what made the law vague was they didn't know what the physician who performs the abortion meant in the statute. And the three judges on the Fifth Circuit kind of reacted the same way, only verbal. Must do this. That's pretty simple. And, in fact, they rejected that. Now, in North Carolina, there's a different argument being made, and it's kind of interesting, because both North Carolina and Texas have exceptions to their law, which Oklahoma doesn't have. In Texas, if the woman has been the subject of a reported rape, the ultrasound is not required. Okay? Because the legislators decided that under those circumstances, that the trauma of at least an early ultrasound, because frankly, the expert witnesses that have given testimony in these three cases have all said that the first 8 weeks of pregnancy, you pretty much have to use a vaginal transducer because you can't, the baby's too small or the embryo's too small. You simply can't see it with a transabdominal running it across the woman's tummy. All right. So the legislature decided that they didn't want to subject the woman to this. So they have that exception. The Texas abortion provider said, well, since they have that rape exception, you know, obviously this is unconstitutional because they're letting some women, it can't be based on health because they're letting some women who could have an ectopic pregnancy be accepted. To which the court said, if you really want us to follow that argument, we'll sever the exception. Right? And that's basic constitutional principles. If there's an unconstitutional provision that can be taken out of the law while preserving the rest of the law, see the Obama arguments, the administration arguments on the health care bill, right? Then you simply take that provision out and leave it intact. So in that instance, what Texas did is they had a rape exception. What North Carolina did is they have two. They have a rape exception as long as the rape has been reported. And they have a fetal anomaly exception. If the woman has undergone an ultrasound within 72 hours prior to the abortion, then that ultrasound can be substituted for one performed at the abortion clinic. And it was done largely because women who have fetal anomalies, hydrocephaly, spina bifida, other serious disorders of the fetus, will undergo an ultrasound as part of that testing procedure, and so the state of North Carolina said you can substitute that ultrasound as long as it has occurred within 72 hours before the abortion. Why the 72 hours limit? Actually, medically, it's quite sensible. Many of those pregnancies will terminate spontaneously anyway, right? Many of those embryos that have these sort of defects, fetuses that have these sort of defects, will lead to spontaneous miscarriages. And so the part of the reason that you want a current ultrasound is if fetal demise has already occurred, you want the woman to know that because then she's not having an abortion. She's having a DNC. And so the idea that you want a current ultrasound in order to determine whether the pregnancy is even, at this point, still alive. And I'm trying to use all the neutral language. all right, at that point, you want to do the ultrasound, because if there's already been, if the embryo or the fetus at 6 weeks, you can't see any cardiac activity, it's dead. It's dead. And so then the proper medical response, according to sworn testimony in these cases, by the majority of physicians, is to say to the woman, I'm sorry, you have a failed pregnancy. We can do one of two things. We can either send you home so that the spontaneous actions of your body eliminating this can go forward with no surgical or medical intervention, and we can monitor it, okay? Or we can go ahead and do what is effectively a D&C. We can evacuate the contents of your uterus. It's your choice, make your decision. Would you rather undergo the surgical procedure now? Would you rather wait 24, 48, 72 hours and see if your body spontaneously deals with this situation? Informed consent. That's why North Carolina has a 72-hour requirement. Okay. So, ultrasound laws, clearly grounded in a reasonably medical requirement, since 95% of the clinics are already doing them. The only thing we're fighting about is whether you show them to the woman and explain it to her. So far, the Fifth Circuit has said these laws are perfectly constitutional. The law in Texas is now in effect and has been in effect for at least 2 weeks. The law in Oklahoma was in effect for 2 days before it was enjoined. Abortion providers in sworn testimony said that they had no problem with complying with it, since they already do the ultrasounds. Okay. North Carolina's law has never gone into effect. The Oklahoma law was declared last week unconstitutional by the trial court level on a basis of a unique provision of the Oklahoma Constitution that says that you cannot modify the claims or the remedies that are available to particular groups. The Attorney General's office has already publicly reported an appeal is in the process of being drafted from that opinion at this point. It's a state constitutional matter rather than federal constitutional. Interestingly enough, you have a professor coming on Thursday who I've debated on this very issue, and at least when we debated at Columbia, she conceded the federal constitutionality of these acts. She just said it's not public policy. So, let's go to the second one real quick, because I want to leave plenty of time for questions. I saw someone up there who started to flag me, but let me go through the fetal pain statutes real quick. The fetal pain, what you see currently pending in Congress, and you see pending in Michigan, and there are 5 states that have already enacted it, and it's Michigan and Tennessee, I think. This is where the PowerPoint sort of, I've got my exact state citations. But I know Michigan is looking at this, and I know that Congress is looking at this. What does the law say? It says that there is a sufficient body of evidence to show that 20 weeks post-fertilization, which is different than gestational age by two weeks, all right? 20 weeks post-fertilization, there's sufficient medical evidence that the fetus feels pain. What is that medical evidence? The medical evidence is that at 8 weeks, your body in utero begins to develop the mapping of all the sensors throughout your skin that feel pain. Okay? You've got the basic brain stem, and you begin to develop what are called neoceptors. Okay? Neoceptors. It takes until, I think, approximately 16 weeks for the whole body to be covered with these neoceptors so that you can feel what's happening. At 13 weeks, the thalamus, which is one of the control stations of the brain, regions of the brain, is fully developed. And so there's a fair amount of evidence that shows that the fetus can feel pain even at 13 weeks. But at 20 weeks, the cortex, which is, if you will, the control central of the brain, is sufficiently developed at that point that there's really not much debate about the physiology, the neurological development of whether pain can exist or not. How do we know that? Because some of these hydrocephalic babies, anencephalic babies who are born without the front brainal lobe, without the cortex, have lived for 3, 4, 5 days, some several weeks. And we can tell by their physiological responses when they're feeling pain and when they're not feeling pain. So that gives us pretty clear evidence that a cortex is not required, but taking the most conservative position, all right? We accept that the cortex is required, and so these laws say that at 20 weeks post-fertilization, all right, abortion should be limited to threat to the mother's life because the abortion process itself creates tremendous pain. Those of you who have been in the pro-life movement for decades, like myself, or even those of you who are deeply interested in it, may remember that President Reagan made this claim when he spoke to the religious broadcasters down in Houston. And it was the basis of a film that's still available on YouTube called The Silent Scream, which opponents or proponents of abortion advocates claim is propaganda, but nonetheless what it illustrates is that when a sharp object or suction is introduced into the womb, the fetus moves away from it. The fetus moves away from it. That wasn't, we knew that back in the 1980s. But what we now know and what's been developed is various studies that deal with in utero surgery. Some of you may remember, and you all are old enough to remember this example. Remember the front page of Life magazine with the tiny finger around the surgeon where perinatal surgery was being done? All right, that picture is part of what's brought us to this point. Physicians now can do remarkable in utero surgery. And that in utero surgery can occur as early as 16 and 18 weeks. Okay? They can go in and essentially remediate spina bifida, which is a huge success, unbelievable. Hydrocephaly, where because of a genetic problem and a physiological problem, the water around the fetus's brain compresses that area so that the brain won't develop properly. And so surgeons now go in and put in tiny little shunts so that the fluid goes out to the amniotic fluid and the brain can develop normally. It's stunning what can be done. It's absolutely stunning. Well, what's any of this got to do with fetal pain? Well, as part of the development of this in utero surgery, physicians began to wonder, how do we make the fetus compliant? How do we stabilize them so that we can do the surgery? It's like trying to move when the person, you see those in the MASH movies, right? People are moving and you're trying to do surgery on them. That doesn't work too well. And so we need to immobilize this fetus that we're trying to do the surgery on. How can we do that? And they've developed fetal anesthetic, which makes the fetus very compliant. The fetus can be positioned exactly where they need to be to introduce these shunts. But not only does it make surgery possible and far more successful, what they also discovered is when they use fetal surgery, when they use fetal anesthetic, the fetus heals much, much more quickly. Much, much more quickly. Evidencing that there is pain that's retarding the natural physiological. Because when you experience pain, when I experience pain, and when fetuses experience pain, and this has been established by blood studies, hormones flood our body. And different cells operate different ways, trying to get to the brain to shut it off. That's what makes you unconscious eventually if you're really in pain, right? And so fetuses have the same blood chemistry. And so it's pretty clear that physiologically and according to neurological development, at least at 20 weeks post-fertilization. At least at 20 weeks post-fertilization. All the equipment's there and all the responses that we would identify as evidence in pain are similar. Fetuses move away from sharp objects when you're inserting the needle to give them that anesthetic. They move away from the curette that may be introduced. They move away from all of this. Okay? It's the same responses that if somebody's unconscious in the hospital that we observe to see if they're in pain and whether to increase the morphine or not when we put someone in that sort of twilight zone to recover. Those of you who have experienced particularly with battle injuries, some of this is really important in that instance. Okay. So physiologically, the responses are pain responses, and neurological development tells us. So what's the argument against this? Why would you not want to do this? Well, one of the arguments that a small group of physicians make, but frankly it's a dwindling group, make the argument that unless you have self-awareness, unless you can say this is my pain, you can't be in pain. It's a philosophical one. I hurt, therefore I am. All right, to paraphrase. But that's not the way we treat the profoundly retarded. And it's not the way we treat unconscious patients. All right. And so the argument hasn't gotten that much traction. But that's the main argument. That if you can't say, this is my pain, if you're not conscious of it, you can't be said to be feeling pain. So we don't need to worry, for example, about that newborn boy that we're about to circumcise. We used to have the same argument in that instance. Now, yes, I see some of the men's faces going, but we now have the medical practice of anesthetizing those children, because that used to be the medical philosophy, right? Well, newborns don't have any self-consciousness, so they can't feel any pain. Those of you who have had baby boys, standing there while they do this, as they scream and thrash. Oh, no, they're not feeling any pain. It's just natural. Oh, okay, fine. All right. So the physiological indicators are there, the heart, blood hormones, etc. So we got rid of that idea with newborns. Why are we still tolerating it, at least at 20 weeks? And I understand why others are worried about this. They're worried about this for a couple of reasons. There are some indicators, even at 8 weeks gestation, that pain's there. But you can't really prove that the physiological development, right? And you don't see the same hormonal response in the blood. But science is developing, and so they're worried about this sort of nose of the camel in the tent. And I get it. I totally get it. All right. The other argument that I think is more interesting, though, that we encounter in this, in trying to pass legislation, is that, well, if the real problem is that the fetus is feeling pain, just anesthetize it before the abortion. If the real problem is pain, put it down like a dog. Now, of course, that's not exactly the words that are used in the testimony in congressional and legislative hearing, but we certainly anesthetize animals. In fact, there's a federal law that requires it to some degree, at least for animals being used in the FDA. PETA would never tolerate killing animals in an inhumane fashion. And at one level, there's not much response to that. If we think that the unborn within the woman is the equivalent of your favorite terrier, I'm not sure there's much more to say except let's vote. All right. But if we think that there is something unique about human pain, if we think that the pain of human beings counts in a different way morally, an argument that the anti-death penalty people make all the time, the foundation of our cruel and unusual punishment provision, then perhaps the humanity of this entity within the woman is sufficiently established by sharing our capacity to feel pain. And perhaps at that point, the state's interest is sufficiently compelling to prohibit. But again, there are some, based on the body language I'm getting, who will be unpersuaded, and fair enough. I hope they at least think I've been fair to their arguments. But at some level, then the answer in a democracy is, let's vote. Thank you. I'm open for questions. Yes.
Fantastic speaker. Thank you very much.
Thank you.
Very much.
Didn't need to be emotional. I meant to be
Well, it's
rational.
an emotional issue.
Oh, okay.
Two quick questions. I say you're actually claiming that the scientific community, the majority of scientific community, agrees that there is fetal response. There is a developed nervous system with cognizable pain below 20 weeks. You're claiming that that's
No,
what the
at
majority
20 weeks,
At
not
20 weeks.
below. And cognizable, that's the fight, right?
Right.
What does cognizable mean? I too am a lawyer, I listen like a lawyer.
Right.
So no, I am not making that argument. I am making the argument that the physiological evidence is undisputed. We would accept it in a born human being.
The physiological evidence of what, though? For everything that I've seen.
The hormones,
Right.
the bloods being flush with pain.
Neuroreceptors being starting at the skin like that. Everything I've seen for actually having a developed nervous system, which requires not just synapses to touch and feel, but to communicate to a brain, to a response system. So that 25 weeks minimum for a nervous center. 28 weeks.
We
is what
disagree
we're
about
doing.
the science there, and that's
Well, I
in
say
fact
that the
not what we're
scientific
saying.
community doesn't disagree about that, actually.
I would argue that they do. In fact, Alberta's province has passed a law where you cannot perform an abortion
Well, I
after
would say
20
that
weeks.
legislation
May I finish,
has to
please?
continue.
Alberta's Medical Association, the Royal College of Obstetricians and Gynecologists, has passed a professional rule that is not unprofessional conduct to perform an abortion without anesthetizing the infant. And in fact, San Francisco's Planned Parenthood clinic in deposition said that they always anesthetize the fetus at 18 weeks and beyond.
Right, but you said earlier, though, that's mostly because the procedure is easier that way. There's reactionary responses, it's not cognizable pain, not a nervous system.
Again, I won't concede that there's not, and so at this point, we'll just disagree about what the science says.
So your claim is, though, that the majority of the scientific community does think.
Yes, that's the way we treat for fetal pain, and that's also the experience with people who have lost their cortex through injury, etc.
Okay, well, I think comparing a fetus, I will disagree on it, but okay. My second question is, we're talking more about the ultrasound, and I think that's a fantastic question. And one thing that I found really interesting was that only 5%, you said, really changed their mind. I would say two things. Is one, that if a woman came through...
No, I didn't say that. Only 5% of the clinics don't do them.
Only 5% of clinics don't. Okay. Well, you say that many women don't change their mind, though. Your claim was that even though they found it helpful, that many women...
According to the 2 published reports from abortion clinics, women rarely change their mind, but the overwhelming majority of them found it helpful information.
Okay. Well,
and 30% in the crisis pregnancy centers did change their mind.
Well, I'm not going to get into the difference between crisis pregnancy center information versus abortion clinics, but my problem here is that, say that the 20% of women that did not find it helpful, the rest of the women that did change their mind, do you think that it's fair for us as a society to create an emotional reaction in women who have already gone in there and say, I want an abortion, and force them to change their mind? And do you think that even the women that did not change their mind may have had a negative emotional reaction to this?
Not according to the reported studies.
So you think
from
that
the
no
abortion
women,
clinics.
You think that no women, not even a small minority, have a negative emotional reaction to they
I can only report what the abortion clinics themselves report.
Okay. So 20%, at least 20% of women did not find it helpful and potentially were emotionally damaged by this issue.
No.
Well, only 80% found it helpful. At least 20% found it unhelpful.
I'd be happy to email you the study.
Okay. Thank you.
Yes.
I agree that ultrasound should be performed, I think, in all cases of pregnancy, just to check for things like ectopic pregnancy,
Fetal demise,
and that sort of thing. Because
right.
I think we, have to be medically responsible. But I think, like, women having to look at the ultrasound, I think the woman should be able to make a choice. Because I mean, there could be an instance. I had a friend who very much wanted a baby. She wanted a baby very much, and she was told she couldn't get pregnant because of a disease she had, and she was really devastated by her infertility. Well, then she got pregnant, and she was told, if you take this to term, it will die, you will die, your body can't do this. So she had to have an abortion, and it was very sad. And if she had to actually look at what she couldn't have, that would have been terrible for her.
That's the justification. It's not a constitutional argument, but that's why North Carolina has the 72 hours, right? Because the doctor who told your friend this tragic news, I am fairly confident, did an ultrasound to see the condition of the child.
So as long as I just think having to look, there should be...
And the Oklahoma law and the Texas law both say that the law is not violated if the woman chooses to look away. But it must be placed within her line of vision.
So what does that mean, the line of vision?
It means that if the doctor, and in fact it was interesting, the medical director of one of the clinics testified, well, we always have the thing where she can see it. To which my answer is, good, you comply with that part of the statute. All right, but the concern is, how do we prove the woman looked at it? So the criminal liabilities, the civil liabilities only attach if you can prove it wasn't positioned. If it's turned, I am the screen, you are the patient. Here I am.
Okay, so, but would they be like explaining the parts of it? I mean,
The oral description is still required in all
I
cases.
think that could be emotionally harmful in certain instances, like if you really wanted to keep the baby but couldn't for medical reasons.
I understand, but less than 1% of all the abortions in this country are due to fetal anomaly. And so, North Carolina, what I hear you arguing is North Carolina's made a good policy decision. I don't think it's constitutionally required.
I have a few concerns, and obviously, as you can tell from my mind, I actually disagree on a lot of other points, morally and so on, but we're going to leave that to the side right now. If you could just elaborate on certain concerns that I had from your talk. First of it being the reported rape issue. I really shouldn't have to bring up the statistics of how much rape is underreported. And even worse, underreported rape getting to the point of actually going to any kind of clinic after not having the strength to even report it. So that's one issue. If you could talk a little bit more about that, if that concerns you at all. Another huge problem I had was obviously comparing fetus to a dog and putting it down like a dog, but you know, that's part of the performance and making your arguments, so that's that.
What would you use the analogy for then?
Definitely not putting down a dog, but even if you were to use that, you know, my personal feelings tell me that I wouldn't want to see a dog in pain any more than I would want to see a fetus in pain. So I don't understand why there would be a problem in doing it that way. But again, I'll let you talk more about that if you'd like. Gosh, there was so much. So let's start with that.
Those two, and then make sure
those.
other people have a chance to ask questions too, rather than. And I'm happy to talk afterwards. And I recognize I'm a little late, but I saw a hand over here as well. Number one, the underreporting of rape. I understand that argument. There's also a significant body of literature that says it's overreported. Now that's from a different group, right? But the data rape concept. Remember the guy, the WikiLeaks guy, who was sued in a foreign country where rape is defined as the failure of the condom. So we can fight about what those real statistics are, and frankly,
I know the restrictions.
I understand. But frankly, I suspect we're on the same side of that issue. I'm not a fan of rape. I will hereby announce that I am opposed to rape. No one should engage in that conduct. All right. So we've got that. And some statutes, interestingly, in legislation, and again, I think we're talking about legislative decisions, not constitutional requirements. Some statutes actually simply allow certification for the physician that's preserved in the medical record. And that is intended to address exactly your concern. If the physician is going to not perform the ultrasound in compliance with the statute, then he must have this, instead of having one certified, which is the way you prove that you complied with the statute in the past, right? You don't have the cops burst in and the woman's not seeing her ultrasound, we're done. What you have is they go through the medical records annually to make sure that the licensure requirements are done, et cetera, et cetera. And so they would look in the file, and if they didn't see an ultrasound report, they would look to see if they had a statement by the woman to the physician. It's a private statement, right? Not disclosed. These are adults, so we don't have a disclosure requirement. If we're talking about minors, we got a different problem, all right? But if we're talking about adults, they would look for a statement from the woman that simply says, I'm the victim of domestic assault, I'm the victim of... So some legislators are equally concerned with you, but think this is a good law and try to address it that way. The second, trying to, again, respond to both of your questions. The second, independent of the language used, the real question is, how do we respond to the existence of what is clearly human panic? Do we think that and many people who believe abortion should remain basically unregulated because they think the industry does a good enough regulation, the clinics themselves, right, would say that in that instance, fetal anesthetic is enough. And as I said during my prepared, kind of, without my PowerPoint, prepared remarks, my only response to that is, let's vote. Because we just are going to disagree. I think human pain is unique. I would be much more harsh on someone who tortured a human being than someone who tortured a dog. Let me go to this side and then, did I see your hand?
Mine?
Yes.
No.
Oh, okay, never mind. Then I can, let me come back. Either way.
Should we, like, is there a middle ground that both sides agree on? Like, if both, in terms of, like, fetal pain, if both sides might agree that if we aren't going to ban it, we should at least anesthetize the fetus, shouldn't that be something to be worked for, that if abortions are going to take place and you're concerned about the pain, that we should at least say, if they're going to take place, they should be anesthetized? And I think most people would agree that if there's pain going on, this should happen. So why isn't there a push to, within abortion, regulate it so that things that we agree need to happen, like fetal anesthetization and ultrasounds, to make sure that there's nothing, you know,
The other
dangerous to
5%
pregnancy,
do the
Yeah,
ultrasounds.
just to, make sure that that happens, and make sure that we're doing things that are, you know, medically sound, and how come that, you know, there's not a push for this common ground.
I've got 3 answers. One is your colleague right behind you, who initially went to why don't we require fetal anesthetic? Okay. One, you've got.
I was shaking my head too. Sorry.
Oh, okay.
I did the same response that you did to the why is there no working group.
Okay, so part of it is just many people believe the science is politicized. Note the exchange here, right? And I think it may well be, because neither side can access the other's research base, right? The most comprehensive research data available is from Guttmacher Institute, which was started by Planned Parenthood, and whose primary demographer, Stanley Henshaw, those of you who write and study in this area, Stanley Henshaw has said in sworn testimony that they don't publish articles that have conclusions that are contrary to what they think good public policy is. And we don't have a CDC willing to do it. People like me can't get access to the basic data because it's all proprietary information. So part of it is we fight over the data. We fight over the man who discovered the needling, the in utero needling and the pain response with the hormones is actually pro-choice and has been berated by publishing his studies because they're being argued in this way. So part of it is just the political conflict, right? The other part is that neither side trusts the other. When you're talking about advocates on both sides. My students are stunned to learn that there are particular lawyers from the Center for Reproductive Rights that I've litigated against several times, and we don't have a drink at the end of the day. Now, that's sort of lawyers, right? And there may be some here who say, how could you drink with the devil? But, in fact, these are decent women who are deeply mistaken about a fundamental fact. And they would say the same about me. All right. So part of that makes it impossible for people to pass regulations like Alberta did that said, as a matter of medical regulation, you know, you have to do the anesthetic. It makes it impossible to pass mandatory ultrasound laws that simply require the performing of it, even though testimony after testimony under cross-examination, the doctors say, well, yeah, you're right. It's the fastest way to identify ectopic. It's the fastest way to identify fetal demise. It's the fastest way to identify fetal anomaly. Yeah, yep, that's all right. But you still object to the law. Yeah, I do. That's a very long answer, but I think it's a fair answer. And now I'm getting the positive head shake, so I would think that's right. Yes, you had another question, and then one more, and then...
No, I didn't have a question. I just wanted to clarify that you misinterpreted my body language based on, I think, the perception you have of my perspective.
Well, you were nodding when she spoke. I didn't know what else to do. Yes, sir.
I haven't seen you for 25 years, and you're still as good as you were then.
Thank you.
I haven't thought about, I'm Art France, I'm teaching.
Oh, it's so nice to see you. You're the criminal law guru.
That's the only thing that you're mistaken about.
And a bioethics book too, but you used to teach criminal law in Oklahoma.
Well, and with my crim law hat on, I've only begun thinking about this idea that you're going to force a woman to sit down, and you're going to require the doc to show her
Well, she won't be sitting.
well, standing, lined up.
They'll be doing the ultrasound
You're going to force
simultaneously.
the doc to show a woman, you're going to force the woman, require her to watch.
No, to hear.
And then, if I understood you correctly, should she avert her glance, there's criminal liability, I would guess, for both of them.
No, that's what I was
Did I
saying.
misunderstand?
Yes. No, in fact, Texas, Oklahoma, and North Carolina all have specific language that says the woman may avert her eyes. And so the fact that she doesn't look, there will be no criminal liability. The rub comes that the words still have to be spoken. And so people say, okay, fine, she doesn't have to look, but she has to hear. To which, I mean, we could do the nuance of, well, no, students don't hear half the words I say in class. So I think they could be perfectly capable of ignoring what the doctor said. But I understand that that's not a very satisfactory argument.
Isn't that turning the doc into a cop? Isn't that perverting physician-patient relations and the confidentiality that you want there to encourage good health care?
It doesn't impact confidentiality any more than signing any other informed consent document does.
Well, except that if the woman is ultimately prosecuted, and
She can't be prosecuted under all three of these statutes.
I understood you to say that there was criminal liability.
For the physician.
Oh, even better.
All that happens is she says, I don't want the ultrasound, and the doc says, I can't do it then.
Or she says later that it wasn't done in an appropriate fashion, and the doc is at risk of prosecution.
There is the possibility, but then she will have a signed document in the medical record that says that he did it properly. So she's going to have a tough row to hoe. And again, I don't think that raises constitutional questions. It may be bad public policy, but we require that all the time. When we go into clinics, for example, in Texas, we had a clinic where their sterilizer had been broken for 12 months.
I'm sorry, I'm really very interested. I don't mean to, there may be other, let me mention one other thing. Sitting here listening to, have you read A Clockwork Orange?
I have.
That's what was brought to mind.
And I would say 1984 is brought to my mind. So take your pick.
I think that's a great point that you brought up about the criminal prosecution element. I feel that there's a natural akin to protecting one's profession, be it in the practice of medicine or law. So to a client that walks into an office that says, I'd like to have a living will, does the attorney have an ethical obligation to say, you don't have to have a living will in the state of Arizona, and you can only rely on a healthcare power of attorney? And if the state forces me as a lawyer to give both alternatives, they're only forcing me to do what I'm ethically obligated to do already. So too, in a similar setting, by analogy, that physician would only be forced to do what he or she is already ethically obligated to do, which is to say, what are the natural consequences of either course, of either having an abortion as a medical procedure or not. On a different point, and this is my question to you.
Can I respond to that one, or do you want to?
No, I have just a quick
Okay.
question. I think that, again, through analogy, when we look at the Harvard studies and the tests that physicians are used when they determine brain death, or so as we expect them to do before an organ donation, pain is obviously one of those factors. My question to you is this: if fetal pain is one element that legislatures and those who are pro-life are wanting to promote, what then is the next stick in the bundle after fetal pain that might be a corollary to the 10 elements to show brain death, or to show that a person is no longer, quote, alive at the end of life? Because the beginning of life and the end of life are the same issue.
And so, well, I'm not sure there's the same issue, but for purposes of argument, I'll accept that at the moment. If I were in oral argument in front of an appellate court, I would not. I'd argue about that.
Understood.
But I would say that I've already noted one of the problems, and one of the reasons people on the other side say that they can't accept this is because if we simply deal with certain things like the needling response, you can make an argument that fetal pain exists as early as 8 weeks gestation. So part of the question is, we'll accept the development of the thalamus and the cortex and the neurological networks there, and we're good with that and that sort of thing. But we're not going to do this because the next thing you're going to ask us to do is you're going to say, well, the cortex isn't necessary for adults, right? And so you're going to move it back to 13 weeks. And then you're going to say, well, even the thalamus isn't necessary, and you're going to move it back to 8. This is the suspicion that you were talking about, which means sensible legislation can get passed by either side. So I think in answer to your question, which elements of the neurological system is required, we make a distinction for brain death or for death in the hydrocephalic and the anencephalic child. I think this is a similar corollary. And so I would say that that's where we're going to see. If there is progression, we're going to see it in that area. So we're out of time. I'm happy to answer questions individually. I've got all the time in the world. So